All right. Well, hello, everybody. Hello again to some of the folks who are joining us again. Hello for the first time to the folks who are joining us for the first time. My name is Eric Finch. I am a former U.S. consular officer and a former USCIS adjudicator. And this is a Boundless AMA with a former USCIS adjudicator. So happy to talk about all the questions that we've received. Happy to talk about any questions that everybody gets interested in during the conversation. And if you have any questions or anything, please just put them in the chat, and I'll be working with our colleague here at Boundless Rapid Visa to make sure that we can get to as many questions as possible. Before we get started talking about the questions that we've received, I do want to remind everybody that I am not a lawyer. I am not a immigration lawyer. This is not legal advice, and this is not intended to guide the decisions of any specific person or any specific legal situation. We're just here to share our knowledge, share our experiences, talk through some of the things that we have questions about, and hopefully help ourselves understand where to go to get the proper legal advice and when that time comes. Okay. So with that being said, let's go ahead and get started. I've got several questions teed up. I think there's some great questions this week, and I'll try to talk through these as much as I can. Anybody who's still confused, sometimes as a former government official, I have a tendency to use slang or jargon that has to do with these processes. So if anybody needs any clarification or anything, just let me know. All right, so let's kick things off. We got a question. If I come through the Mexican border, can I marry a U.S. citizen? Okay, so this is a little bit vague, and I'll talk through some of the different things that are involved here, but why don't we start with two scenarios, which is if what is meant by if I come through the Mexican border, if that means to travel into the United States without a visa, not at a port of entry, so to cross unlawfully into the U.S., which, no judgment, many folks have done that. Many folks' parents have done that. There's a lot of people in America in that situation. And, if the question is about what's next, how do I, do things that normal people want to do and get on with my life and find jobs and relationships and things like that, that's where I'm going to operate from with this question. Okay. And then in a moment, I'll shift to, sort of people who did cross with a visa or other things like that and what the implications of that will be. So one thing I can say that applies to both cases is, anybody can get married to whoever they want. And I recognize that that's a blanket statement that hasn't always been true for certain LGBT folks and things like that. But as it stands now, in the United States, there's no restriction on folks who don't have a valid immigration status when it comes to marriage. You can marry who you want, who you love, or who you want to be in a relationship with. And I think the question for a lot of folks in this context is, if I do that, then what's next? How does that affect my immigration status? What are my options? Like what type of things should I be thinking about in order to, adjust my status to something more permanent, things like that. So we'll kind of talk through that. So I think I've referred to this before in these conversations. I think the important thing here is this concept of lawful entry, right? And lawful entry is a requirement for most types of immigration benefits that are processed within the United States. So if somebody enters with a visa, whether it be at a land border or at an airport, and they go through customs or they cross the border checkpoint, they present their documents and things to the officer, and they are given a thumbs up or a stamp or waved through by hand or any combination of those things, then that person has been lawfully admitted and inspected by U.S. immigration authorities. And for those folks, whatever happens after that, can have consequences. If you perhaps have a tourist visa and then you overstay for, longer than the period that was granted you, then obviously you'll fall out of status and there could be some other consequences that come with that. But fundamentally, you were admitted and inspected, and therefore that requirement, no matter what happens after that, as long as you don't leave the States, that requirement has been met. So going back to folks who don't have that lawful entry, who traveled across the border without being inspected or admitted, did not go through a border checkpoint or present their ID or their photos or visa, their ability to change status is going to be very limited in the United States, and that's permanent until you leave and come back with some type of valid entry, right? So the way that this plays out with a lot of folks like DACA is DACA folks are a good example of this, where a lot of folks, depending on where you live in the United States, because the circuit court laws that apply to programs like DACA can be a little bit different in different parts of the U.S. for cases and precedents that haven't reached the Supreme Court. But generally speaking, folks who grow up in the U.S. without lawful status, without a lawful entry, who then go on to marry a U.S. citizen, you have to think of it this way, which is like you have a qualifying relationship for an immigration benefit. You have a U.S. citizen spouse. And of course, you can file a petition. That petition, again, assuming the relationship is valid, that petition will be approved, the I-130. But you also have a problem when you go to adjust status, which is you're not eligible to adjust status, because one of the requirements to adjust status is a lawful entry, in which you were inspected and admitted. So there's various ways to overcome that. Some folks, like I said, in some parts of the country, they've ruled in the courts that the receiving temporary protected status, receiving DACA status counts as a lawful admission. Some areas parole. So if you were paroled in, as part of an asylum claim or something like that, they can look at that as a lawful admission. If you have that, you're golden, right? Okay, because you can meet that requirement. And then the other thing that comes up with a lot of folks who have long-term unlawful status in the U.S. is they've also overstayed their visa for quite a while. And that really would only apply for folks who were here before they were 18, turned 18, remained in the U.S. And in order to overcome that unlawful period of stay, which is separate from the entry and admission issue, then there's different ways that you can approach that, right? Like some folks will get provisional waivers. Other people, which allows you to sort of apply for the waiver before you leave the States and then leave the States and get a visa and then come straight back. Other folks can find other programs or things. If the U.S. government ever passes major immigration legislation, there's been talk about, often called amnesty, but that's sort of a blanket. Everybody who's here is okay from now on to apply for things. I think the important thing to understand with amnesty is it doesn't really, and it never has, completely just awarded some benefit to people. It just removes restrictions, and generally it just removes restrictions and requirements that allow some portion of people who weren't eligible to apply before to apply. So going back to my example of the folks who entered with a visa, those folks would have potentially a lower barrier because they have that lawful entry. They're able to apply. They meet that requirement. And then there's other things that come into play, right? Like I said, there's the unlawful presence issue, which can be overcome in various ways. There is the criminal records issue. Folks who've lived here for 2 or 3 decades may have had some issues with the law at some point. That's a separate type of ineligibility that has to be overcome on its own basis. And some of this stuff can be addressed through waivers, which can be submitted to the United States Citizenship and Immigration Service alongside or after you file your initial adjustment paperwork. Other things are going to be something that has to be tackled when it's identified as a problem by the USCIS adjudicator. So, long story short, marry who you want to marry. Don't let the fact that the immigration situation is complicated prevent you from living your life and building relationships with the folks you want to be with. But when it comes to immigration, there's going to be some questions and things that you need to discuss in order to find the right pathway to get that green card status and to get that citizenship. Okay, I know that one kind of a long one. Happy to answer any follow-up questions. Next question is, and I want to preference the pre-submitted questions because folks, prior preparation, we have to respect that. But I will get to a couple of the questions that were just submitted during the conversation in just a moment. So second question, how important are tax returns when it comes to green card applications? Important, okay? Because one of the requirements to adjust status in the United States, and one of the inadmissibilities folks must overcome, is the public charge rule. The public charge rule, broadly speaking, is designed to guarantee that potential immigrants don't become dependent on the U.S. government for support after they arrive here. And in order to capture that requirement and overcome that inadmissibility, you have to submit, along with your I-485 adjustment of status form, a I-864 affidavit of financial support. Now, usually the petitioner, your sort of U.S. citizen or LPR person who's filing for your immigration benefit, will be the primary sponsor, meaning that, their income and their assets will be looked at by USCIS to ensure that they meet what they call the minimum income requirement for the household that you have. So, if it's just you and your spouse, then those two people, if you have children involved, they would be counted. The amounts that are required to support those family units goes up depending on how many family members are involved. And tax returns become part of this process because if you are planning to overcome this public charge requirement based on the income of the sponsor, the petitioner, then, they need some way to prove that they have that income, right? And anybody could say, hey, I make $1 million a year, but who is the agency in the U.S. government that's really looking at this stuff? The IRS. And that's who you file your taxes with. So that's sort of the gold standard. And, if you're filing on income to the U.S. to IRS, they're accepting those returns. You're paying your taxes properly. Those tax documents, tax records. You can get tax transcripts from the IRS, which is more like a final sort of short readout of the successful filing that you did for any given year. But in one form or another, they're going to want that tax information from IRS to prove those income and salary figures that you're claiming. And if you don't have those, if you're not filing taxes, you can have an extremely difficult time proving to, if you can't prove to the IRS or you're not telling the IRS how much money you're making, USCIS is not going to put a lot of credence to those numbers that you're claiming. So, this is one way where sort of IRS and USCIS work together indirectly to make a determination about whether people can overcome this ineligibility. So yes, if you're thinking of sponsoring somebody, if you're thinking of being a joint sponsor for some acquaintances or people that that may need this assistance, you're going to want to obtain either official tax records, tax transcripts. You're going to want to make sure those amounts are reflected, the income level that you have is reflected properly on your tax documents. And you're going to be submitting those tax documents to USCIS with that I-864 form. Usually you're required to submit the prior year. And most folks submit the prior 3 years. Yes, this did become a problem for many folks who were unemployed during COVID. Whatever their income level had been up to that point, they faced a year with little to no income. And it's become very challenging for a lot of folks in 2021 and 2022 to successfully sponsor people as a result of the irregular income that they had during that period. So it's very important. I would, if you're about to get involved in an immigration process that is subject to the public charge requirement, I would look at, go ahead and start gathering these documents, making sure they're accurate, making corrections if you need to with IRS. And the other thing I'll mention real quick, tax returns, there's one other area where I think they get looked at a little bit during the immigration process, and that's evidence of relationship. So for folks who are applying to adjust status as a spouse, in most cases, one of the things they look at, aside from the public charge requirement, and I say they, I mean USCIS adjudicators, is they want to make a determination that your relationship is authentic. And one of the things that married couples do is intermingle finances. Not in all cases, and you've heard me talk about this during these conversations before, where different couples have different arrangements for how they organize their finances and things, and you should be prepared to talk about that. But one of the quick shorthand ways that USCIS adjudicators will try to identify whether a marriage is legitimate, for folks who are filing CR1s or who've been married for a certain amount of time, are you filing your taxes jointly? Meaning, is that a spouse that you're now petitioning this immigration benefit for reflected on your income taxes? Now, this kind of goes back to the marriage question. If you are filing, if you're not at a point where one or both parties in the relationship are, under some sort of legal status or everything, you need to also kind of understand that is a tax issue. And, the expectation is that if two folks get married who are employed and making money in the U.S., they would be filing those taxes jointly. Not in all cases, not all the time. And if that's not the case for you and not the right choice for you in your relationship, that's something that you would want to just be prepared to talk about during the adjudication phase. But the baseline is usually the assumption that, after people have been married for a year or more, they're going to go ahead and move into that joint filing status, especially if they had children, just because if for no other reason, then it's very beneficial for you from a tax refund and liability standpoint. So, I think that's the important things to know when it comes to tax returns. And let's move into one of these other more recent questions. I'll do this one real quick, just for the sake of being thorough. So the question is, as an immigrant with an F1 visa, is it possible to obtain a driver's license with the ITIN number? This one I can't really give a good answer to because driver's license issuance regulations depend on the state. Some states are very flexible and don't really require, don't require a social security number or anything else. Other states, I can imagine, are probably requiring social security numbers and things. Some states have programs where they give you like a license or a driver's license that says like not a permanent resident or, on a temporary visa status versus a full license. And people who adjust often have to go back to those DMVs and get new licenses once they move from a temporary visa to a permanent green card or other status. So sorry, I can't provide a better answer to that question. I think it'll depend more on the instructions and regulations at your individual state's Department of Motor Vehicles. And I do also want to point out something that is little known, which is a lot of states in the United States have reciprocal agreements with states or entire other countries to issue and respect the driver's licenses that are issued in the U.S. or in that other country. So wherever you come from, if you already have a driver's license, it may be worth looking into the place that you're going. In this case, it was an F1 student. So, if you're going to college in California, you may want to look at the DMV. Say you're from India, does that DMV, will they respect the driver's license issued in India? Vice versa. Like one example I had when I worked in South Korea for many years was South Korea. It's quite expensive and difficult to get a driver's license, but they would respect any driver's license that was issued in the U.S. So you had foreign students a lot of times who would obtain relatively easily obtain a U.S. driver's license, come back to South Korea, use that U.S. driver's license as evidence that they had obtained a license elsewhere, and then be able to skip certain parts of the process in their home country. So it's just a good example of one of those things that's like worth looking into and understanding. Like in the U.S. where you can take a driver's license issued in Texas and use it somewhere else if you're traveling through without residing there and things. There may be some benefits or opportunities or shortcuts that you can do depending on your specific country and where you're going to be in the U.S. Okay, next up we have there was kind of two of these, I think. I'll do these two together. So question one: my wife got her photos and fingerprints done January 11th. How long does it take to get to our interview? And question two, somewhat related: immigration agent told me my green card was approved on my interview on May 12th, but I have not heard anything since. No letters or updates online. So after you submit your packet, so you've assembled all your paperwork, you send everything to the agency. It'll go to a lockbox. They'll pull out all the documents. They'll make sure, first and foremost, that your payment method clears. That's when they accept your case. They'll notify you, usually by email and paper mail, and they will provide the receipt numbers that they've assigned to your case. Now, that is your sort of that's the key to everything that's going on with your case as you progress through the USCIS system, right? So you got your receipt numbers in hand. Something's happening. You don't know what's happening. Usually the next step is within a month or two, you'll get a notification, an official I-797 from USCIS by mail. So make sure you keep your address updated. And that notice will inform you, where and when you need to go to get your biometrics collected. And there's a couple different terms for this. Yeah, so that I think they're called applicant service centers. So they'll say it's an ASC appointment. You'll go. A lot of times very inconvenient. Like maybe it's 2 weeks from now. You don't really get any choice over the time or date or anything like that. You just get informed like you need to show up on this day. They'll go in. Usually that's pretty quick. You'll go through security. They will collect your fingerprints and a couple other pieces of data from you, and then you'll be good to go for that day. Not everybody has to go through this step. USCIS, especially post-COVID, if you've already had a ASC appointment for some other purpose, sometimes they'll reuse those biometrics and everything and skip this step. But yeah, that's usually the first thing that people do in the immigration process, especially if you're going for one of the more complicated benefits like a green card or adjustment of status. Okay, so next up is you wait for another, probably 4 or 5 months for like a immigrant visa filing or like something along those lines. And and then you'll get your, interview notice. Now, in the interim, you can get RFEs because things are still happening with your case, right? Once you get, the biometrics thing is basically a box the agency has to check. But, if you have a adjustment of status packet, it's going to a service center, it's getting sorted through, one of the more junior officers will look and make sure that all the documentation is in there that's supposed to be there. Somebody will look at the I-864 form that we just talked about to make sure that the public charge issue looks good. If everything is in order, sometimes they'll pre-approve that part of it, so the ultimate adjudicator at the field office doesn't need to mess with it. And then, once the, file is complete, they'll go ahead and send it to the appropriate field office inside the U.S. or, in the case of the consulates, where you're applying for overseas, they'll send it to the National Visa Center to start the process to schedule your overseas interview. And in that case, the NVC will do the 864 processing and collect some additional documents from you. And then, that's usually around the time that you get your interview date. Once it arrives at the field office where the interview will take place for an adjustment status case, they'll slot you into their interview schedule. That can be pretty quick after it's ready out of the service center for places that have a low wait time. For other field offices that perpetually have like a long backlog, that could be that can extend your processing quite a bit, right? If the case, whatever time it took to get you to the field office, if they've got a 6 to 8 month backlog, there's another 6 to 8 months that you're going to wait. And a lot of times, it's not the USCIS online case tracker doesn't really get into a lot of granular detail with these movements. So you may see something there where it's like your case is being processed. It doesn't tell you when it goes from service center to the field office. The first thing that you kind of hear after the ASC appointment in a lot of cases is just, hey, here's your interview date. And, you may have waited 6 months or a year at that point for an update or more information. So, and then anything along the way that they find is missing, you can get an RFE. And basically from the agency's point of view, they will stops the clock for them if something's waiting on something from you from an RFE. So they're not really going to consider that part of their processing time if they're waiting for a response from you. That's why it's really important to respond to RFEs as quickly as possible in a complete manner, that addresses their concerns. And you get to the field office stage, you get your interview scheduled, and that, like I said, is a function of what's going on with wait times at the individual consulate or the individual field office. And once you get your interview, which is what this second question addresses, as much as possible, USCIS adjudicators will try to give you some sense of what the outcome of the case will be at the time the interview concludes. I think for me, a lot of times I would finish and say look, this looks complete to me. I don't see anything missing. I'm going to review it again, but if there's no other discrepancies or issues that I identify, I'm going to approve this. And that, I think, may have been what the person who asked this question heard. But there's something you need to understand about what happens during those interviews. USCIS adjudicators, there's a number of ways that they organize and assign the cases that they need to process and interview every day. One of the ways that they assign it is by giving them a large bundle of cases, maybe 6 to 8 cases for, a regular day. And those cases, at most the officer may have 20 to 30 minutes to review those before you actually walk in the room. Is 20 minutes enough for you to review a 3-inch thick file with hundreds of documents? No, it's not. And they have to take the time, whether before, during, or after the interview, to do a thorough review of that file in order to have the information they need to make a proper adjudication. Other offices, they have even less time, in case where they're assigning cases as the officers become available. In that case, the person may grab a folder, have a chance to flip through it for 5 or 10 minutes maximum, and then immediately call you in and conduct the interview. So basically, in those kind of scenarios, usually they'll try to make a good judgment, based on what they've seen so far about whether that case will be approvable. And 9 times out of 10, that judgment is correct. So, you leave, they spend another hour, maybe at the end of the day, going back over everything. It looks good. They do all the stamps and computer actions they need to do, clear you through the security checks, and you're good to go. In which case they send a electronic transmission to the print facility where the green cards are printed. That gets printed and then automated. Again, keep your address updated. That gets sent directly to you at your address with the finished green card. congratulations. For folks who, complete their interview, hear something positive, and then are still waiting, so for example, the question here was May 12th, now we're in July. Does that sound like a lot of time that, like an unreasonable amount of time for somebody to like kind of wrap things up and finish? Yeah, that's a long time, right? You've already waited a year, 2 years. Now it's been another 2 months. You don't know what's going on. You don't get any updates. But there's a number of things that can happen, right? If they do find something that they're concerned about after you leave and, before they're able to approve the case, a lot of times if there's something missing or just like something they want to update or some evidence that they wanted to collect that you didn't have at the interview, they'll send you an RFE. But in a lot of cases, if there's a complex legal issue or something that needs to be explored with, an agency lawyer, or if there's something in the file, even from several years ago that like wasn't resolved or handled properly, then that can initiate a process that can take quite a while. They'll have to review that with the other legal professionals at the agency. They'll have to get opinions from their managers and supervisors. They'll have to, in some cases, reach out to other parts of the agency to understand specific incidents or things that occurred and what the outcome was. All of those things can extend your processing time. And, unfortunately, and I've talked about this before, the agency does a pretty good job of tracking and making sure cases are moving through the process up to the interview. But once the interview occurs and it's in the hands of an individual adjudicator at the field office or elsewhere, that person basically has, within reason, as much time as they need to complete that adjudication properly. And that can extend out to weeks or months. Folks are busy, other offices trying to get information passed back and forth. There may be other files they need to look at that they need to find and have sent to the office where they're working. So there's any number of things that can pop up. I think all you can really do, is keep an eye on your online tracker, respond to any RFEs, promptly with the correct information. And then, if you reach a certain point, I think the agency, certainly for like naturalization cases, like the expectation at the agency, and I think by U.S. law, is that they'll be adjudicated promptly. So whatever problems there are, those should be identified and communicated to you pretty quick. For adjustment of status, it's a little more loosey-goosey. Like they can take some extra time, they can look at things, they can tee up investigations, they can write memos and talk to legal professionals and things like that. And you don't really have a lot of ability to understand what's happening. All you can do is wait. So, all right, that is that. I will go back now and look here at some of the other ones we had. There was one, is the Ombudsman real? So the USCIS, periodically you'll see either research or statements issued from the USCIS Ombudsman office. Yes, they are real. Yes, they are charged with. There's some disagreement about the actual degree of power that this office has, but its mission statement is to sort of I'm paraphrasing, to oversee, to review, to fact check and understand things that are going on in the agency and act as a kind of authority within the agency to examine things and identify problems, make suggestions on how to improve service. And they're real. They are real. And, there's a number of, it falls under the categories similar to like the Inspector General's office at some other agencies. And they have slightly different roles depending on what, how the agency is constituted and the specific powers that they're given. But yeah, they're real. But I think you'll find that without direct power over the other parts of the agency that they're sort of reviewing or overseeing, their ability to force change and force the other components to do things is very limited. So a lot of times they'll make suggestions. If those suggestions get implemented, great. If the agency, that other part of the agency decides that's not a priority for them, or they have other ideas about how to solve the problem, sometimes they won't act promptly or at all on the suggestions created by the ombudsman. So, it's good that government agencies in the United States have some degree of oversight, both internal and external, by Congress. Does it always lead to very responsive and positive change? Unfortunately not. So Yes, it's real. No, it can't solve all the problems that USCIS has, unfortunately. All right, next one we got. There's a question. This one, I'm not 100% sure I can give a great answer, but there's a question. Why do some service centers take so much longer than others? I submitted my I-130 in March. How long do you think it will take to get government approved? It's for consular processing in Chile for my spouse. This is an area of intense interest for many folks who are planning to immigrate to the U.S. Now, just to kind of give some background, so the way that USCIS works in the United States is probably not the best model for customer service. And, I've talked about that in various ways. But like I said, roughly speaking, the process is you submit your paperwork. It goes to like a lockbox where, what they call a lockbox, which is really like a fee processing facility where they do some basic like organization of the case and things like that. Make sure it meets some like minimum requirements. And then the vast majority of all cases and most petition, family-based employment, like most of the petition types go through the service centers. Most of the, change of status requests and like basic forms, anything that doesn't require like an actual interview is mostly going to be done at a service center. So the question is like, why do things take so long? Why do certain centers take longer than others to do what seems like the same things? And when I say service centers, like I don't know the exact number, but the USCIS, as it expanded and grew, especially post 9/11 after the creation of DHS, they created these like large facilities where it's not customer facing for the most part. They can have a large number of employees who are able to do, they break them up into units to handle specific like forms and tasks. And the thinking is like there's a lot of like economy of scale and efficiency to be gained by just like pushing almost everything that comes through for a certain pipeline, through a dedicated group of individuals at a certain place where they can focus on that. And that system breaks down a little bit with like super high flow things like I-130 petitions, where it's like they do have some regional adjustment where like if you're living in a certain part of the U.S. it goes to one, if you go to another part of the U.S. it goes to the other. So let's think about that for a second. So we have these service centers where, civil servants, some contractors, some of these places have hundreds, if not thousands of employees, and they have people who are all the way from like entry level to junior management, middle management, senior management, to like the highest level of the executive service of the government. And, the people that operate those service centers obviously work under the direction of, USCIS headquarters in DC, but also like the consulates overseas. In order for them to operate effectively, like they need to have some degree of latitude on how they operate and like what procedures they follow and things that they do. And in practice, that leads to like some degree of discrepancies when, perhaps Service Center A has decided that, everybody who does process X needs to fulfill these requirements. And like, we accept this particular type of document for this process, but not this. And, it's a natural process in a bureaucracy where like certain other things, maybe at another service center, they've established a different standard. Maybe they're just not taking the time to like make sure that, both hands are, doing the same thing. And, that's one example of how things can diverge a little bit. But in actual practice, I think the strongest impact is just staffing, which was, like all businesses affected by COVID. If there's a service center in California that's doing something and another service center in Texas, where are those places at? What's the labor market look like? Where, what more complicated processes are being done alongside the basic process at, one service center and perhaps not at the other. There's a number of things, leadership, management, morale that can affect like the efficiency of these units and what they're doing. So yeah, it's going to, and I think USCIS realizes that it's not optimal when one place takes twice as long to do something as the other. And it makes, it certainly doesn't feel great for the customers. And, there's been some efforts in the past for like applicants to like try to game the system by submitting things to certain places they think will do it faster than others. Or submitting duplicate, petitions. If something's stuck somewhere, they wanted to try to submit it somewhere else to see if they can get a good result. And I would kind of caution against that. You got to really just follow USCIS directions and accept that the process is the process. It could really gum up your application if you have multiple versions of it floating around, if things are being done with one and not the other. Even if you have some kind of short-term gain in that you get something approved or removed faster at the end of the process when you're really trying to get that green card in your hand or get that benefit approved, you don't want to have a bunch of duplicate processes and workflows gumming things up. And if somebody sees in your file that you've got a bunch of different things, there's nothing wrong with having multiple petitions and things like that. A lot of folks do that for family and employment based at the same time. But, somebody's going to need to look at all that and make sure that it's all in the right pipeline and being processed properly. And the more complicated you make that, the more you introduce potential problems into your process. So yeah, that's what I'll say about the service centers. We're running up against time. I think I got time for one more. Let's see what we got here. Here's a good one. Why does USCIS cancel interviews, and how long do they take to reschedule? So canceling interviews, it's not done often. I think USCIS does everything they can to avoid it because they know that it's extremely disruptive and difficult for customers and people who are applying for immigration benefits to deal with those kind of changes. So a few things I've seen, like if they have a agency-wide system outage, they may realize that the morning and when they get to work, those interviews are going to have to be canceled. COVID provided a number of examples of reasons. If you have a severe outbreak in a unit, you're understaffed. They'll have to make the difficult choice to reschedule there. Natural disasters, large scale protests. You have to remember that in a lot of states, these field offices are located in either the capital city or one of the bigger cities in the state, and that folks, some folks have to travel a considerable distance. Like in Oregon, people from Bend or from Eastern Oregon would travel several hours to get to the Portland field office. That's a tough thing, if you're told day of, when you already came up and got a hotel room or something hey, we're not going to be able to do things for you. So I think they realize that. And in the time that I worked at USCIS, this was used very sparingly. I think there was a strong consideration for how difficult this made it for the applicants. But one area where they're not as great or not as considerate is the second part of this question, which is how long did they take to reschedule? This one, I think it depends on the circumstances, right? For folks who, received a short notice cancellation because of some emergent, tornado or, something they didn't really anticipate, but also was very short notice thing. I think they work really hard to try to reschedule those. I know in particularly for naturalization, they would try to refile and get set up, a new naturalization ceremony and stuff. They know that people want to get through this process, but, again, they have to deal with the reality on the ground. And at that point, you're competing against a number of other people who've waited just as long as you have. In some cases that may push the interview back, a month or several months, depending on how busy that consulate is how busy that field office is and what the backlog looks like. So yeah, I think it varies a lot. It's not going to feel really great, no matter why. No matter why, what the underlying reason is. It's obviously not going to be great news from an applicant perspective. But again, this is why it's so important to make sure your address is updated and things like that. Whatever prior notice they can give you, they will. You want to make sure that you're in a position to receive those notices and react properly to them. And then you want to make sure that your new appointment information is sent to the right address so that you'll know when you need to go ahead and get started planning to go back up to the field office again. So I think that we'll probably just kind of wrap up for today there. Thank you very much for your attention. I hope this was useful. Once again, just want to remind everybody, I'm not an immigration lawyer, not a legal professional, and nothing you hear on this conversation is meant to be legal advice. I want to be helpful. I want to share the knowledge that I have. I want to hear from you guys. And, I want to keep doing these AMAs. And, I just really enjoy, this engagement, getting these great questions and learning more about, how folks experience the immigration process from the outside and what information that they're looking for. So thank you again, and we'll see you next time.